Yes, and you're not allowed to have corporations except by way of a charter which eventually
Or by act of Parliament.
yes, which is a way of privatising the costs of empire and raising revenues at the same time as building an empire. So corporations were political instruments. And Americans, after fighting their independence, didn't want to be recolonised by the corporations. Well, anyway, that's why I'm into obligations, that you shouldn't externalise the cost of regulation of government. Also, have a conversation with that.
Perhaps we should mention that there are these cuts.
Yes.
We are counting.
Ugo says, Ugo thinks there's the smell of something here, of gas, he says, but I don't know what he's talking about. I don't smell anything.
What's that?
Ugo says that there might be some sort of smell around here.
There is a funny smell.
Is there?
It's a new auditorium, I suspect. It's the smell
Possibly,
of
yeah.
It's been built in an old
Possibly.
It's a sort of chemical residue.
You want to say that please down?
Yeah, I will say that. I will say that. No.
I'd say now, David, while they're still moving around.
Yes. Good morning, everyone. While you're still moving around and sitting down, you will have noticed that there's a handout which is provided by Professor Pettit as aide-memoire for his talk. Not everything in here will be covered, but I'm sure that you will find this an interesting read. It's my pleasure to introduce this morning the second keynote of the symposium that will be given by Professor Philip Pettit, who will represent philosophy in our interdisciplinary endeavor looking at corporations and governance. Philip Pettit, as you know from the blurb written here, is the Rockefeller University Professor of Politics and Human Value at Princeton University, as well as Distinguished Professor of Philosophy at the Australian National University. He specializes particularly in moral and political philosophy, and as well in philosophy of mind and metaphysics, social ontology, and these kinds of interesting, fascinating things. Much of his work, and I'm summarizing, so I'm not going to do justice to his work, but much of his work has been concerned with the links between freedom and republicanism, freedom and corporate agency, and these are the main themes that are, I would say, recurring, at least on my reading of Professor Pettit's work. Among other publications, he has published on the topic specific to today a fascinating book called The Common Mind at Oxford University Press in 1993, A Theory of Freedom, which is also at Oxford University Press in 2001, Made with Words on Hobbes' Language, Mind, and Politics at Princeton University Press 2009, and even more related to the topic under discussion today is this wonderful book co-authored with Christian List, the group agency, The Possibility, Design, and Status of Corporate Agents. So if you are not familiar with this, this is a must-read if you are interested in the philosophy of corporations. I will not say anything more because you're not here to see me. So without further ado, I pass the floor. Please welcome with me Professor Philip Pettit.
Thank you very much, David, and thank you for the cheap plug for the for the book with Christian List. Now, I should say that the themes I'm covering in today's talk draw in good part on my joint work with Christian List, rather than just on my work alone. But let me say, first of all, thanks to the WINIR. Is that how that's the received pronunciation? WINIR, as in the winner, not the loser, the winner. Okay. So my thanks to the WINIR committee for having invited me to speak at this opening symposium. It's a great honor. I'm very pleased to be here. So typical of philosophers, I'm going to start with some definitions. In fact, the first half what I'm going to say are basically, the comments are going to be directed to the idea of what is an agent and then what is a person, and in what sense is a corporation a person. And then in the second half, I'm going to look at the related questions as to how far, qua persons, should corporations be able to claim certain rights, and how far are they subject to responsibilities or obligations. Okay, so I should say there's a whole section at the bottom of the first page of the handout, which is, if you look carefully, you see it's in angle brackets. It's because I'm not going to talk to the themes in that particular section. It would take simply too long. Although I may just mention that it's that material that got me particularly into this topic about group agency and the nature of corporate entities. And it draws on the work that I did with Christian List. He and I proved a social choice theorem, a theorem in judgment aggregation in 2002. And there have been a lot of theorems following it in judgment aggregation. But it turns out it's very, very, I think, those theorems are very important for arguing that there is a real sense in which group agents, corporate agents in particular, are agents over and above, distinct from the individual agents who make them up. Now, I know that sounds mysterious, but it's capable of being, I think, defended in a wholly unmysterious way. That's the issue of how autonomous they are. I'm going to set that aside in today's discussion, but I would love to talk to anybody independently about those themes if you're interested. So just to go back to basics, so what do we think? What is an agent, first of all, since a first move in any discussion of corporate responsibility is going to be the claim that corporate bodies in general, corporations in particular, or firms or companies or businesses, for the moment I'll use those words interchangeably, corporate bodies and corporations, by everyone's account, are agents of some kind. So what is an agent? Typical philosophers to ask that sort of question, I know, but let me just go back to a very basic thing. Imagine you've got a robot. Christian and I actually started this example in our book. Let's suppose it's a robot here that, think of it like R2-D2. You remember that little robot from that film Star Wars, right? And you've got R2-D2 there, and it's got these little blinking eyes that seem to scan how things are. And it stays stationary, let's suppose, except when it sees a chair that's on its side. And as soon as it sees a chair that's on its side, you can see the eyes blink, and it wheels itself over to the chair, and then with its little arms, it lifts the chair up. And then it goes to rest again, but scanning all the time. But if you turn a chair over, let's suppose, R2-D2 turns, sees the chair, as we say, moves towards the chair and lifts it up. Now, is that little robot, terribly simple robot I've described, and there are robots like this in existence now, even much more complex than that, but is it an agent? Well, in one basic sense of agency, it is. And what's that basic sense? Well, there are two ideas in the idea of agency that it exemplifies. First of all, as a system, this robot is clearly forming representations, as we say, of its environment. As those little bug-like eyes swivel around, it's presumably getting input from the environment, like the chairs that are on the side. It's processing these inputs in such a way that, as we say, it gains the information that a chair is on its side rather than upright. Second component, it's got a purpose or a goal built into it by the designer, presumably, maybe reprogrammable from occasion to occasion, and the goal is to put chairs upright rather than that are on their side. And what does it do then? Well, it pursues that goal according to its representations. It acts for the realization of that goal in a way that's sensible, given how the environment is according to its representations. Now, if it's going to be a successful agent, it's got to satisfy two corresponding conditions, conditions corresponding to those two elements. First of all, it's got to have representations that are, as we say, evidentially reliable. In other words, the representations that are pretty accurate in general. It represents things as they are. It doesn't think a chair is on the side when there is no chair on the side. And if there is a chair on its side, it tends to notice that. So it's evidentially reliable in its representations. Secondly, it's executively reliable in the sense of when its representations depict the scenario as one where a goal isn't satisfied, but it is in a position to realize that goal, then it executes the action required. It acts so that its goal is realized in the environment as it represents it to be. Now, what is an agent? Well, an agent is just a system that has goals and has representations. Representations that are evidentially reliable, they tell it how the environment really is, and where it's structured to pursue, realize its goals according to those representations so that it counts as executively reliable as well. Of course, no agent will work to realize its goals according to its representations in every possible environment. Conditions have to be, as we say, normal. So, for example, if you turned off the lights, even R2-D2, assuming that it's working, with light, is not going to be able to notice chairs on the side. It has to be under what we think of as independently plausible normal conditions. Now, the robot's a very, very, very simple agent in that sense of agency. Of course, animals, non-human animals, are most of them equally agents in that sense. You can identify goals, you can identify representations, like the dog. The ears go up, it hears the gate. It's got a goal to get supper or to meet the family or whatever, and it goes racing towards the gate, just like R2-D2. Of course, it's got many more purposes than R2-D2 and many more representations. It hasn't just eyes, it's got ears, it's got smell, and so on, and all of these come together. And human beings, obviously, we equally have goals, and we've got representations, and we act to pursue our goals, to realize our goals, according to our representations. Groups do that too. Corporations in particular do that, but lots of groups do that. Lots of corporate bodies have got clearly goals they pursue. Maybe it is maximize shareholder profit or whatever, and it pursues those goals according to its account of its environment, in this case, exactly the opportunities for investment, the likely profits, etc. That notion of an agency, by the way, it's very, very simple, but it's built into decision theory, which I guess most of us have been introduced to at some stage. After all, representations in decision theory we call subjective probabilities, goals we call utilities, and when we say in decision theory that the rational agent maximizes expected utility, that's just a fancy way of saying, with obviously some formal details in there, it's a fancy way of saying the system pursues its goals according to its representations. Okay, so if that's the notion of an agent, we now have to introduce the notion of a person if downstream from here we're going to ask the question as to whether corporations can count as persons. Now, when people raise that question, what is a person? I think the wrong way to go about this is bottom up. The wrong way to go about it is to say, well, we're all persons, so let's look at us and think about us, and let's ask what's special about us. That usually isn't a very profitable way, I find, of introducing the topic, because people focus on all sorts of different features about human beings. And they say, that's what it is to be a person. So, for example, if you're of a religious mentality, you might think, well, a person has got a soul. That's what makes a human being, rather, special. And then you get the idea, well, a person is an agent with a soul. Of course, that leaves the question of what is a soul. But I just use this example to explain why I don't think that just thinking about human beings and then asking what is it makes them persons is a very useful way of doing it. I prefer to approach it top-down rather than bottom-up. Of course, this is stipulative, but let me give you a definition that I think is going to work out pretty well of what it is to be a person. According to what it is to be an agent, what I've said, an agent is a system that's representable, you might say, capable of being represented by us now as pursuing goals according to its own representations, its judgments, its beliefs, or whatever. The thing about a person is it's a special sort of agent. It's the agent which isn't just capable of being represented by us outsiders as having goals and pursuing those goals according to its judgments or its representations. It represents itself to us. It communicates to us the very goals that it has and the representations that it has, and it invites us, this is now stipulative so far, I'll exemplify it in a moment or illustrate it, it invites us, the observers, to interpret it according to its own word. It invites us to ascribe goals to it of the kind that it actually ascribes to itself and communicates to us that it has, and it invites us to ascribe judgments to it that it itself communicates that it has to us. So in that sense, it speaks for itself. It says, no, okay, watch my behavior if you like, but let me tell you what I believe. Let me tell you what I want, what my goals are, and then hold me to those words. At least that's a first shot of what it is to be a person. But it actually does fit even with us human beings, if you think about it, because while the animals, not human animals, that is, never tell us what their goals are, and so it's a matter of real interpretation. What is the dog trying to do, sniffing around the tree over there, whatever it might be? You've got to work it out. What is even the chimpanzee trying to do, whether in the wild or in an experimental environment? That's a matter of our interpretation. But when it comes to a human being, human beings are at least capable of telling you what, according to them, they are trying to do, and what, according to them, are their views about their environment. We do that with one another. Okay, we don't just give an account of what we want and what we believe, that just may or may not be accurate. We give an account of ourselves in that sense that we generally live up to. So I say that a system, an agent, should count as a person if, first of all, it represents itself to other agents who will themselves actually count as persons, and in general, it lives up to its words, so to speak, to its communication. One thing, though, here's something that's really worth emphasizing. I might talk about David's beliefs, or I might talk about David's goals. So I might tell you, for example, that David intends to go to the dinner this evening. Suppose David doesn't turn up at the dinner. And you ask me, well, how could you told me that he was going to be at the dinner, but he didn't turn up. So explain yourself. Are you a liar? Were you trying to mislead me? And of course, I will probably say, well, actually, I heard him say, or I assumed he would be, he's a member of the committee or whatever, and it's the formal dinner of the conference. So, that was my evidence, but obviously it was misleading in a certain way. I excuse myself. But notice, if you say to me, are you going to be at the dinner tonight? And I say, yeah, I'll be there. And I don't turn up. I can't say about myself, well, I was pretty sure that I intended to be there, but I must have gotten my intention wrong. I must have been misled about myself. The evidence about myself must have been misleading. You can't do that, can you? It's sort of silly. You can't talk about yourself when you represent your, in this case, an intention, as if you were a third person. You can't excuse getting yourself wrong by saying, oh, must have misread my mind. So if you say, someone asks you, where is Lugano? Is it in Italy or is it Switzerland? And I say it's in Switzerland. And it turned, well, let's say I say it's in Italy. And later you say, do you really believe that it's in Italy? Because you see, I'm looking for Swiss francs, for example, at the exchange, rather than Italian. It's the euro now, isn't it? Rather than euros. I'm going to say, well, that's really strange. I thought my belief was that it was in Italy. But actually, I realize now, because I am looking for Swiss francs, not euros, that I must have believed all along that it was in Switzerland. You can't do that. It just makes you silly. So this is to say that when you do communicate what your beliefs are, or your intentions are, as in I'll be there, you're not allowed, so to speak, under conventions of language, to excuse getting yourself wrong by saying the evidence must have been misleading. You don't speak about yourself as a third person. One way of putting that in a slogan is you speak for yourself. You don't speak about yourself. I speak about David when I say that he's going to be at the dinner this evening. I speak for myself when I say I'll be at the dinner this evening. Now this is very important. Of course, we speak for ourselves even more strongly when we make promises or pledges. I said I'll be at the dinner this evening. That was sort of casual. If I don't turn up, and you say, you said you'd be at the dinner, I could say, well, I just changed my mind in the meantime. I mean, I did intend at the time, but I changed my mind in the afternoon. I thought I could go somewhere else. There was a good film on or whatever music event I wanted to go to, and that's fine. It excuses me. But of course, if I promised, which I might have done, as distinct from just avowing my intention, I might have promised to be there, then I can't even use the I must have changed my mind excuse. Because you say, but you promised. The convention is you can't use that excuse with a promise. So two ways in which when you speak for yourself, you really invest the words with a sort of authority. One is that you're not allowed to say, got myself wrong, as you might with the third person, and you're not allowed to say, if it's a promise, must have changed my mind, as of course you could also do with a third person. So you really speak for yourself in an important way. Now I think the best notion of a person, persons are agents who communicate to one another what their states of mind are inviting one another to interpret them on the basis of those words and generally live up to those words. And when they communicate their minds to one another, their attitudes, their beliefs, their goals, and their judgments, when they do that, they do it also putting aside various excuses. So they do it expensively. Their words are not cheap. They're the words of people who speak for themselves in that way. So that's my notion of a person. It's actually, of course, many of you realize it's a notion that Thomas Hobbes made prominent in the famous chapter 16 of Leviathan, where he introduces this notion of a person. It had been there, I'll speak about that in a moment, it had been there earlier, but Hobbes really brings it to the fore. And he explains the actual etymology of the word person, as in persona means a mask used on stage. And to be a person is to put up a mask and speak through the mask. Persona is to sound through. Sono, I sound, to sound through the mask. To be a person is to hold up an image of yourself, like a mask in a theater. To speak for that self to others, and then to live up to what you speak for, to live up to that image that you project of yourself. That's what it is to be a person in this very basic sense, at least so I suggest to you. Now, of course, we human beings are like that. We are agents who speak for ourselves. So we do satisfy this notion of what you might call a functional notion of a person. Because notice, it doesn't presuppose that we human beings are made up of any particular stuff. You could believe that human beings have got souls of an immortal and non-physical kind, or you might believe that we don't have any such distinguishing mark from other species. Regardless of what stuff we're made up of, if we function in this way, that we're capable of communicating our attitudes to others and being held to them and living up to them in general, then we count as persons, personal agents, if you wish. Notice that that notion of a person is very specific. So, for example, on this account, a fetus is certainly not a person. But I don't mean to, though I have views on that, I'm not going to defend them, I don't mean to say that therefore, that means that arguments against abortion are baseless. No, of course, there are lots of arguments you could put against abortion, for example, that are not based on the notion of a person. When people say it's because the fetus is a person that abortion is wrong, they're using person in a different sense from my sense. They're using it what's sometimes called a moral sense. So what I mean by person is just a functional sense, but it's a well-defined sense of person. Now, with those notions of agency and personhood or personality in place, let's turn to, can groups of agents incorporate so as to be persons in that sense? And of course they can. Suppose, and this was actually Hobbes' example, suppose that a group of people pick a single individual and they say, you speak for us. Interesting that we use that same expression. You be our spokesperson. My account of a person, an individual person, is, after all, an agent who is a spokesperson for himself or herself, an agent who can use these words authoritatively and can be held to them in speaking about their own attitudes and communicating them. Now, a group can decide to have a spokesperson, a particular individual, let's suppose, who speaks for them. And what does it mean if the members of the group authorize that single person to speak for them? Well, it means that when that person, when that individual speaking for them says, we won't settle for less than such and such a wage per week. Let's suppose it's a union leader who is authorized by members of the union to speak for the union. And he or she says, we won't settle for such and such. If they've really authorized that person as a spokesperson for them, then what that means is that they're going to behave in such a way as to back up those words. They're not going to say, for example, oh, well, sorry, he got me wrong when he said that. No, he was authorized to speak for you and for others in the name of the group. So just as when I as an individual say, I'll be there at the dinner this evening, I'm required in order to act up to those words, as we said, to live up to those words, if I'm going to function properly as a person. But that's exactly what a group does when one individual speaks for the group and they commit to living up to those words. What they're doing is they're performing exactly in the way I perform when I live up to my words. they're performing as a single person, which is exactly the sort of language that Hobbes endorsed. Hobbes thought that you could only really have, his views are more complex than that, so let me not get into Hobbesian scholarship, but he certainly thought the paradigm way in which a group forms and acts as a person, and for him an example is a company of merchants, for example, there usually is one single spokesperson who is authorized to speak, as he puts it, with stint, within limits for the company of merchants. But the company becomes a single agent insofar as they rally behind those words in the way in which we each rally behind our own words. If we're going to pass muster as a person, we all rally behind, we the merchants, behind the spokesperson for our company, and thereby act ourselves as if we were a single person. That's his picture. What he doesn't recognize, but is clearly the case, is that we might equally have decided that on certain issues, Bloggs speaks for us, on another issue, Smith speaks for us, on yet another issue, Kelly speaks for us. And so we've got three spokespersons, but that's okay, provided the voices behind which we rally are actually coherent. They're not dissonant with one another. So you can have a division of powers in that sense, consistently with having a single voice. It has to be a coherent voice that these different voices generate, so they coordinate with one another if there is dissonance, if we are going to be constituted as a company. And of course there are as a group, as a person type group. Of course, there are other ways in which such a group agent might be constituted as well, but I hope the picture is sort of clear. So to be an agent is just to have purposes that you pursue according to your own judgments or representations of the environment where they themselves are evidentially reliable. To be a person is to be an agent like that, but in addition, to be able to speak for what your purposes are and to be able to speak for what your judgments are, and in general to be reliable in how you speak. And in particular, it's to speak for what those purposes, goals are, in a way in which you can't speak about a third person, at least not without his or her license. It's to speak about yourself in a way where you can't let yourself off the hook. You can't excuse your words being wrong in various ways. Okay, and in that sense, that functional sense of personhood, clearly groups, it seems to me, can actually be persons. They can rally behind a single voice, whether it's the voice of an authorized individual or a voice that's generated under an authorized procedure. Okay, now, what I've said so far was, I think, is nothing new. It was essentially what I think medieval thinkers had already come to. In 1246, the then Pope, who was a lawyer, Innocent IV, writing about the scholars of the University of Paris, said of that body that it was a persona, but a persona in the phrase that became common, a persona ficta, F-I-C-T-A. By saying it was a persona, he meant it was a bit like us individual human beings. It was a persona. In saying it was a persona ficta, he meant to say, and this becomes clear in that particular papal bull of 1246, he meant to say that it couldn't be excommunicated. There had been an issue in church law as to whether a group agent, like the scholars of the University of Paris, you might just say the scholars of Paris, there was an issue as to whether a group like that could be excommunicated. And he wanted to say no, because excommunication carries the penalty of going to hell, and no group can go to hell, because a group doesn't have a soul. So what he says is, although it's a persona ficta. Unfortunately, that word ficta in medieval Latin, as I understand it, is ambiguous. It can mean either fictional or pretend person. And that's how the philosophers took it. So for example, Thomas Aquinas, writing 20 years, no less, 15 or so years after that papal bull, that papal, not sure if it had the status of bull, that papal communication, took Innocent to have been saying that really groups are not persons at all. They pretend to be persons. on the other hand, though, that was one interpretation of ficta, fictional. The other interpretation of ficta is artificial. It comes from the Latin fingere, for those of you who remember your Latin, and fingere can mean to make up, as in to pretend or fabricate, or it can mean to actually construct, as in to make something real. The lawyers all took persona ficta to mean an artificial person. Now, the interesting thing is, of course, if a group agent is an artificial person, then it can't go to hell. It's not a natural person, but it's still a person. If it's a pretend person, a fictional person, it can't go to hell either. So it's really not clear what Innocent's own intentions were in using the phrase or the cognate of a phrase of saying that the group agent is a persona ficta. He had in mind, by the way, for example, not just a university, like the University of Paris, but also a guild, or a monastery, or a parish, or a town. These are all represented, certainly within years of his having used that phrase, they came quickly to be represented on all sides, the philosophers and the theologians, philosophers on one side, the lawyers on the other. They were all an instance of a persona ficta, of a fictional person. But the philosophers understood it in the fictional way, the lawyers in the artificial way. Now, Hobbes in the 17th century is well aware of that background, and in fact uses the notion of a persona ficta to describe the commonwealth, as he puts it, or the state. He wasn't the first to do that, though he claimed to be the first to do that, but then Hobbes always claimed to be the first to do whatever he did. And in that case, actually it had been done by Bartolus back in the 14th century. But he says the commonwealth is equally, he doesn't use the phrase, but is a person, but though not a natural person. He uses the word sometimes a fabricated person, he uses various terms. I think the best interpretation in contemporary language is to say that for Hobbes, these group agents were artificial persons, real persons in the sense I explained, functionally real persons. They could speak for themselves. Their words were uttered with authority in the sense that no one could say, he doesn't speak for me. Actually, I can't help recalling. I hope you've all seen that wonderful film, The Life of Brian. And do you remember that marvelous scene where the John Cleese character says, well, he says in effect, the Romans have done nothing for us. Or he says, what have the Romans done for us? And do you remember the hands go up? Well, there is the hospitals and the roads. Well, that's a case, obviously, they're not rallying behind the voice of the leader of the Palestinian people's, whatever group he represents. They're failing to be a group agent, but a group agent has to rally behind those words, has to live up to those words. And insofar as you've got an organization, in the medieval terms, be it a guild, be it a town with a town council, be it a monastic order with its own organization and its own governing body and membership and so on, each of these, there's a voice that speaks for that body, and the members rally behind that voice. They don't give the excuse, he got me wrong, or the voice got me wrong. They authorize the voice like we authorize our own voice, and they count as persons. When, for example, Blackstone, if you look at Blackstone's Laws of England then, and his characterization of corporations, it's really very, very interesting to see that, you know, what he's saying is really, it's the wisdom of 600 years. He talks about the 5 rights of corporate persons, and they're exactly as you well, we'll get onto the issue of rights, but it's this image of personhood that he has in mind. Now, the section I'm going to leave out, I want to argue that persons in that group sense, group agents as Christian and I also call them, I think there's an important sense in which they enjoy an autonomy that it became fashionable to deny. Of course, Aquinas denied it, and the whole tradition of philosophers in the medieval world did deny it, but it became particularly fashionable to deny it, this autonomy of these persons, in the 19th century with utilitarians. In particular, John Austin, the utilitarian jurisprudent, was insistent that group agents were just figments, as he puts it, that it's a façon de parler to talk about them as persons. But that was a minority tradition, I suggest to you. The longer tradition has these entities as persons, and I think that tradition can be justified on the basis of the sorts of judgment aggregation results that I talked about. But I'm going to put those aside. I'm just now going to move on in the second half of this presentation to talk about whether corporations, corporate bodies more generally, and corporations in particular, what rights or whether they should have rights, and if so, what rights they should have, whether they have obligations or responsibilities, and what responsibilities they should have. So 2 questions in each case. With the case of rights, first of all, should they have rights? And then if so, what rights should they have? And with the case of responsibilities, should they have responsibilities? Should they be held responsible? And if so, in what domains? What responsibilities should they be assigned? In what domains should they be held responsible? Okay, well, I think the question of whether they should have rights is more or less straightforward. Let me consider that question, first of all, with regard to corporate bodies, which can include universities, churches, voluntary associations, NGOs, a whole raft of possible bodies, rather than corporations in particular. And here's the argument. It's a very simple argument. It's of the form, if P, then Q, P, therefore Q. So if corporate bodies are going to be allowed to exist at all, in other words, if groups are going to be allowed to rally behind a single voice and to commit themselves to living up to that voice, making, for example, promises as it makes promises in their name or as it announces beliefs or judgments in their name. If group agents or corporate bodies are to exist at all, then I say they have to have the rights that define the areas where they can operate, the areas where they can rally, where they can state, give an account of purposes they have, of judgments they have, and can rally behind that voice. They have to have some rights if they're going to exist. Of course, that should be clear, because after all, if you said, well, it's okay for a group like the group of us in this room to incorporate, to rally behind a single voice. We establish a procedure for determining what the voice is. It might be to make David the plenipotentiary to speak for all of us, or more plausibly, it might be to have some sort of voting procedure with veto points, etc., in the group. But if we're going to establish ourselves as a group, say a group to pursue an environmental agenda, then that's not going to make sense unless the broader society gives us the right, in other words, allows it to be legal for us as a group to pursue that agenda or to pursue it in one or another domain. So if we're going to exist as a group entity, we have to have some rights, operational rights as you might define them. That's the if P then Q. If it's got to exist, it's got to have rights. The P is that if it's allowed to exist, the P is that it should be allowed to exist. And here's why. Insofar as individuals, and I'm going to assume this is reasonable, have rights of association, rights of free association. We're going to talk about constraints on that right in a moment, but assuming individuals have the right to associate with one another, i.e. should have that right under law. So in other words, assuming it's morally okay or proper that individuals should have the right to associate within certain bounds, just as they will with one another. One way of individuals associating with one another is precisely to incorporate under a certain procedure for determining a voice and to contract with one another to rally behind that voice. Well, I assume that people should be allowed to associate with one another in a whole range of ways, and if any of those ways gives rise to a corporate body, which surely plausibly there must be some ways in which they can associate to that effect, then of course corporate bodies have to be given operational rights. So just it's a very simple argument, but I'm probably not presenting it terribly well. The picture is this. If corporate bodies should be allowed to exist, they have to be given certain rights, but corporate bodies should be allowed to exist, otherwise you have to trample on the rights of individuals to associate with one another as they will, and therefore corporate bodies have to be given certain operational rights. So there's no question about whether they should have rights. That's sort of my answer to that question. Now, of course, remember the corporation, as Simon made very clear last night, I thought, the corporation is a very special sort of corporate body, a very special sort of group agent, and that's because it has very special corporate rights, very special rights given to it. Arguably, there are 3 major rights that a corporation has, a company, an incorporated company, business enterprise has in general practice, though they weren't always explicitly recognized in the law at every stage since the existence of corporations over the last 400 years or so. The first is, and the main one is, and I understand that only came into law strictly in England in the mid-17th century, is the right of asset lock-in. It relates to what Simon was describing yesterday, I think, as asset partitioning. So, for example, prior to, I think it was the 1650s, companies of merchants could certainly get together as partnerships. Now, they were group agents, all right. They're rallying behind a voice in various ways. But the thing about a partnership as a group agent is that the partner can pull his or her resources out of the enterprise and go home, so to speak, with those resources. But from once you got the right of a group to lock in the assets of the group, you denied individuals the right to pull out their resources and go home, so to speak, and use them for their own purposes. Of course, what you did allow quickly those individuals to do was to sell their share in the company profits or assets. That's a different thing. But the company now was guarded against, this particular group agent was guarded against the danger that partners would pull out and let it collapse. So asset lock-in was really the major right, I think, that came into existence once corporations properly, that's to say business corporate bodies, came into existence. The other two rights that quickly came on stream, informally if not formally, with that first right was the right of entity shielding, which was the right of the company not to be pursued for the losses of a particular member of that company. It was shielded against the losses of any single member. So I go broke, I'm a member of a company, and the company can't be pursued by my creditors to repay the losses that I, in my private capacity, incurred. And the third right, of course, is limited liability, which, as we all know, is the right for the individuals to be protected, so their resources can't be invaded in the event of the company going bankrupt. Those are very special rights, and it was those rights that established the joint stock company as distinct from the partnership. Okay, so should, for example, corporations, should any group agent have those rights? Should any group agent in that sense be allowed to become a corporation? And I think most of us will say yes, because while those rights are very special, they're particularly special in the case of limited liability, because limited liability extends to the law of tort, so that, at least in many cases, so that by giving a company the right to limited liability in tort, you're actually suppressing some rights on the part of individuals to take that company to the courts under, well, you can take the company to the courts on the grounds that it's liable in the law of torts, but the individual's resources, private resources, can't be invaded by way of providing a remedy for satisfaction of that tort. So it's a very special right. Should they be given those rights? Well, I think most of us think probably yes, because the balance of costs and benefits works out on the benefit side. By enabling joint stock companies to form, you enabled, obviously, capital to be centralized, an amazing buildup of capital, which was crucial in the development of the canals and the railroads of the 19th century and indeed the 18th century in the case of canals, and for the various other enterprises that were important for society as a whole. So surely yes, but now the question is, what rights should corporations, in particular corporations, I'm going to focus on them now, what rights should they be given? Well, the position I particularly oppose, I must say, is the position that is associated with the 1886 finding of the Supreme Court in the United States in favor of Southern Railways against Santa Clara County. Well, it didn't actually it found for Southern Railways against Santa Clara County on quite independent grounds, but in the course of that, the Chief Justice is reported as having said that that we take the corporation, this had been one of its defenses against Santa Clara. Well, let me fill that in. Not all of you may know this. I spent enough time in America to have learned all about it, but what happened was this. the Southern Railways was taxed by Santa Clara County basically for I think the posts that went on the sides of its railroad through the county. It claimed that the railroad owed it taxes on the basis of this property, these posts that ran beside the railroad. And the company had various defenses against that, one of which was that it didn't actually own these posts. That was a very low-level defense. A very high-level defense was that it was a person. And in 1868, that's almost 20 years previously, the US Congress had passed a law, the 14th Amendment to the Constitution, rather, had introduced that amendment. It was designed to help emancipated black slaves, which said that, among other things, that every person should enjoy equal protection before the law in every state of the United States. And so the fifth defense, it was a very high-level defense of this company, was that it was a person and that Santa Clara County was taxing it in a way in which it didn't tax local companies, and that therefore it wasn't getting equal protection across the states of the United States, and hence that this tax was illegitimate. The Supreme Justice is reported as having said that while we fine for the company on the grounds of it's not owning the posts, if I remember the details correctly, we do all agree that a corporation is a person who is protected under the 14th Amendment of the Constitution. Now, that was a very dramatic move, and that move, which became part of US jurisprudence and is basically at the root of lots of recent decisions, including Citizens United, basically was used to extend freedom of speech, for example, to corporations, and in particular freedom of political expenditure, given money is taken to be a form of speech. But notice the idea is that corporations are persons, and hence, like natural persons, they have a protection against the laws that may be introduced. And that protection is based on these constitutional provisions that are meant to recognize, so to speak, the antecedent reality of individual persons as persons, but equally now the antecedent reality of these corporate persons. Now, if you do go that way, it does get to be quite hard to explain why these corporate persons should not have rights, at least on the same basis as individual persons. If you take the line that my definition of a person supports, you're going to go a different way. Here's why. You're going to say, well, these corporate bodies should have rights insofar as the individuals associating who constitute that body thereby should have rights of association. Then you're going to say the rights they have, those corporate bodies, these corporations in particular, they should be restricted on the same grounds in which we often restrict the rights of association of individuals. So, for example, we restrict the rights of individuals to associate in order to establish a mafia-type gang or to conspire in performing crimes. We have all sorts of limitations on the rights of individuals to associate with one another. Well, if we put constraints on the rights of individuals to associate with one another, and if corporate bodies only have rights insofar as the individuals have rights of association, whatever constraints apply to the rights of association of individuals should apply to the rights that we're prepared to give to these corporate bodies. So let me just make that a little bit more concrete, that this still has to be sort of very hand-waving in order to show what I have in mind. So, for example, there are two sorts of rights in particular that you might give to corporate bodies that would actually be, well, it seems to be, subject to question. Let's think of one as the powers you give to such a body, or their political rights, if you like, and the other as their social rights, their rights in relation to other individuals, other persons, in particular other natural persons in the society. Well, one question is this: should a corporation have political, or a corporate body in general, have a power such that some members of the body have political power over other members of the body in the private polities, so to speak, of the corporate body? Well, notice that we do actually put severe limitations on how far individuals can have those political powers within a body. For example, in legislating against various sorts of religious sects, whereas we think of it, the leaders of a sect are often sometimes given a sort of influence that is, as we think of it, nefarious and often underhanded. Think of the Jim Jones, or what was that group that where the leader, called on members to commit mass suicide back in the 1970s. Clearly, we want laws against that, permitting a group to form where some individuals have that awful power over other individuals within the group. Now, that same sort of ground for putting limitations on a sect leader's power could provide grounds for thinking about the sort of powers that we give managers, for example, within a corporation. So, for example, it seems to be a fair question to ask. Within a corporation, we allow managers to have their salaries determined on quite a different basis from the basis on which we allow employees or regular workers to have their salaries determined. And we know notoriously, I suppose it's more sharply or more saliently true in the United States, we know that corporate managers are rewarded on the basis of the advice of firms that often depend on the goodwill of those very managers to give them business. And so you get recommendations for remuneration of top managers that is really in the control of those managers themselves, where when it comes to employees lower down, of course, it's the free market, as we say. So that would seem to me, on the face of it, an area where a question can be raised as to whether corporations should have that right to have quite a different basis for determining the remuneration of top managers from the basis on which the remuneration of lower employees operate. In the realm of political power still, an issue to raise with any corporate body is whether it should be given power of a public political sort, a power as a body, or a power for some members of the body, over the government of the country, the polity in question. Well, we have a long tradition here of thinking, for example, that churches, which is our corporate bodies, or that a church in a given country should not have that sort of power over the government of the country. We have a long tradition of thinking about, in different terms, laicite, or separation of church and state, and severe limitations on how far a church can influence a government. We think that's quite natural. We've no problems with it. So churches should be allowed form and so on, but no church should be given, in many jurisdictions, and most of us think probably in all jurisdictions, should not be given a legal right to be able to exercise control over the government of the day. Well, the same should be true, I would say, about corporations, for example, or any corporate body, not just churches. So the corporations should not have the right, which now they have under Citizens United, I would say, in the United States, to exercise extraordinary power over the government of the day by giving their favors, political favors. In particular, those powers often accrue to the top managers, because who the top manager favors with political donations is usually not subject to any proper discussion, certainly not at the annual shareholders meeting or at the workers' council or whatever, maybe in the board, but even then in only a cursory way if I'm reading the evidence aright. So that's a real question again about whether, in allowing individuals to associate, in particular to incorporate under the corporation form, whether or not we should put limits on the public political power, separating business and state in the way in which we've learned to separate church and state. I could go on, obviously, but another important way is that if we allow people to associate and incorporate, we often, we're in danger of giving these corporate persons, and therefore their members, or maybe some of their members, more rights than individual persons vis-a-vis one another within the society. So let me give one example. It's said often, but it seems to me in a very glib and empty fashion, that you can always take a corporation to court. I love a remark that Mark Galanter made in this context. Many of you will probably know it. He said, yes, well, that's like saying that human beings and sharks can both swim, without noticing that there's a big difference, because sharks are in the swimming business. But equally, you know, with corporations and individuals, they're in the litigious business, right? They really know how to do it. They've got much greater resources. They in many jurisdictions are allowed actually hire the best lawyers and hold them on retainer. And of course, they can actually put, in many jurisdictions, they can put their expenses in going to court against their taxation liabilities, which as an individual, you'll normally not be able to do. So there, again, they've got a lot of advantages. Anyhow, we're all, I think, aware of this. I just want to suggest that if you take the line I'm taking, which is that certainly corporate bodies are persons insofar as the individuals who associate within them rally behind the voice that's constructed procedurally for that body. Certainly corporations in particular should be allowed to exist, having the rights that are distinctive of corporations. But as with any corporate body, the rights that we give them should be constrained in the way in which we naturally think the rights of individuals to associate with one another to pursue their purposes should also be constrained so as not to hurt third parties. And the constraints these would argue for, I just gesture at some here, are constraints, for example, that would limit the private political power of some members of a corporation vis-à-vis others, the public political power of the corporation as a whole or some members in the public world, and equally the social rights of members of the corporation itself in dealing with other natural persons within the public world. Now, the other issue is, should corporations have responsibilities? Here I'm going to be very brief. Partly I have written on this at length elsewhere, and someone in an earlier session was nice enough to talk about my work, but of course we weren't all there on that issue. The line I take is broadly this. When is an agent fit to be held responsible? And of course, dogs and animals are not fit to be held responsible, I would say, despite a long European legal tradition of holding them responsible, although happily it withered away in the 18th century or so. Well, I learned as I was brought up in an Irish Catholic faith, and there were three conditions we were always given, and they're really rather good, for committing a sin, a mortal sin, as many of you will know. One is that, of course, it's grievous matter. A second is that there's full knowledge of the guilt, and the third is there's full consent of the will. Well, those three conditions can be satisfied by almost any corporate body, and in particular by corporations. Lots of decisions corporations make are certainly involve grievous matter. They really impact on the interests of other people. Secondly, there's knowledge of the guilt in the sense that any corporation is always capable of forming judgments that its members are capable of forming. For example, a judgment to the effect that if we take such and such a line, for example, we're a car company, in allowing cars that are dangerous in a certain respect to stay on the roads without a recall, many people are going to die as a result. They can make that judgment. But equally, they're capable of full control or full consent of the will in the sense that they're capable of acting on that judgment. We all believe that. Well, to the extent to which they satisfy those three conditions, I say a corporation, any corporate body that satisfies them, is fit to be held responsible. There's no question about that. So in the range where they have rights, fine, they can operate as they will if we give them those legal rights. But when they breach those rights, they are perfectly fit to be held responsible for the breach of those rights. No problem there. One question, and this is the final issue, what responsibility should corporations have? My own view is the following, that while a corporation, of course, never acts except through the acts of individuals, its members, those it hires, or whatever, well, that's certainly true. When a corporation, for example, is at the origin, let's suppose, of something we regard as a serious misdeed of whatever kind it might be, perhaps leaving cars on the road that are actually going to cause the death of many, many people, then I say that there's two levels of responsibility that should operate. You should hold the corporation responsible, but you equally, I'm talking about morally responsible. How far you should hold them criminally responsible, legally responsible, is going to depend on other considerations. But this is a prima facie case for holding them legally responsible as well. You should hold the corporation responsible, but you should equally hold those individuals responsible for what they did in cases where they could have refused to do it. Now, one response is to say, well, wait a moment, why not just hold the individuals responsible? Isn't it double counting if you hold the corporation responsible as well? I've got two responses to that there at the bottom of the second page of this handout. Think of this as an aid memoir, if you like. And they're, first of all, that when someone acts in the name of a corporation, performing a misdeed of the kind or making a decision of a kind that we regard as objectionable, then while it's true that that individual chooses to perform that action in the name of the corporation, it's also simultaneously true that the corporation has programmed for that action to be performed, so that if the individual dropped dead, almost certainly they'd find another individual to put in his place. Or if the individual says no, they just have got a backup to put in his place. That means there are two distinct actions. The corporation programs for what's done. The individuals implement that program. Those are distinct actions. You can find both responsibility at both levels. The other consideration is that, fortunately or unfortunately, individuals often have perfectly legitimate excuses for behaving in a way that they agree is objectionable when acting in the name of a corporation. And that is that sometimes they weren't privy to the knowledge as to what would happen as a result of their doing that. Sometimes it was that, well, they'd lose their job if they didn't do it. It can be one or another excuse of that kind. If you just hold individuals responsible, you're going to have many cases where there are deficits of responsibility, so to speak. It's only if you hold the corporation responsible you can be sure of avoiding that deficit. In 1989, I think it was, the Herald of Free Enterprise, very famous case, many of you will know of it, sank in Zeebrugge. It was a British company. There was a report that said this company was appalling. Its record of negligence was extraordinary. It hadn't done all sorts of stuff. There were failures of backup, failures of monitoring, and so on. And it should be held criminally responsible for the sinking, while individuals were equally responsible, but it was a matter of their going along with tradition and being negligent in a sort of offhand way. The courts actually let off the corporation, and of course as a result of that Britain introduced the Corporate Murder and Manslaughter, Homicide and Manslaughter Act of 2008 on the grounds that a corporation could not be criminally responsible. I think that was a real deficit in the law, and that's what the 2008 new law, I think, sought to recognize. Of course, the individuals involved, no one could be really pinpointed as having done anything awful. They were just following procedures. It's just there were awful procedures that ought to be monitored and corrected for. So those considerations suggest to me that just as corporations should have rights, but very limited rights, constrained on the basis I've described, they should be held fully responsible for any breach of those rights and should be held responsible in their own name, even simultaneously with individuals within those bodies being held responsible in their individual name. Thank you.
Thank you.
I better stop.
Right, we began a bit late, so we'll run over 1 p.m. We'll finish at sort of 7 or 8 past or 10 past or so. I'm sure there will be lots to discuss. I would suggest that we take couples of questions together. Please keep it brief and to the point, and we'll let Professor Pettit answer following that.
Thank you for the very inspiring lecture. I have a quick question. Can we say that legal personality is the main feature of a corporation, and asset partitioning and delegated management directly derive from legal personality, while limited liability is a derivative of asset partitioning and delegated management? And from an ontological point of view, I would say, as you said, we can't hold two different entities responsible for the same act. So we can't hold the corporation and one or more members responsible or liable for the same act. So can this be like an answer to the reason, the rationale of limited liability, just as a construction of limited liability as a derivative of asset partitioning and the decision-making mechanics based on the delegated management?
If I follow the question properly, I think, yes, that legal personality, as I understand it, is a byproduct, really, of asset lock-in. I mean, all group agents, including partnerships of a commercial kind, they're all group agents in my sense. I mean, maybe it's what Simon had in mind by the firm. If you could imagine for a moment a firm that operates without the, as you said, the legal aspect of being a corporation, it would be a number of individuals who presumably are going to make contracts with one another, for example, or with other such bodies, if they're going to operate commercially, like a church, like a voluntary association, like an NGO or whatever. It would count as a corporate agent. Once you allow asset lock-in, a couple of things happen. One is that, for example, you almost have to introduce a juridified language. You can't any longer say that the members, as you might have described them, of the firm share in controlling or share in owning, for example, if they do, the assets of the group. You could have said that prior to asset lock-in. Once you have asset lock-in, no, they don't own it. It's this entity you think of now as distinct from them. The company, the corporation, is said to own everything. They just own shares in it. Equally, those who manage the firm are now, they're the directors of that new entity, this legal personality. And equally, those who contract with the firm contract with that legal entity. So for purposes of law, it's as if there's this special sort of juridified entity over and beyond the group agent itself. So I think that is a facet. Now, the second question that you asked, I'm not quite sure about the linkage between them, is I agree that two agents, well, they can be held responsible for the same act if they participate in doing it, for example. Two individuals may commit a murder. They're each can be held responsible for someone's death, for the act where they simultaneously kill him or kill him together. Okay, but when you've got a corporation and an entity, human individuals, whose actions just are the actions of that corporation, if it were exactly the same action, I would have a problem about saying both agents can be held responsible, the individual enactor of the act and the corporate sponsor of the act. So actually, I prefer to think of it that what the corporation does is it programs for the effect. It organizes things so that whether by this individual or that individual or the other individual, the act will occur. Whereas the individual is the one who assumes the role of actually implementing that program. Those are different acts. Now, I think that that distinction, though, is available even if the firm was not corporatized or juridified in the way I've talked about.
Abraham?
Hi, Abe Singer, University of Toronto. So I really enjoyed the talk, and I agree with the basic conclusion that corporations ought to have attenuated rights of some kind and responsibilities. So the devil's sort of in the details. I guess I'm curious whether the account you give actually gives an account of why corporations have rights or should have rights, and it isn't just an account of the more specific style of the individual right to associate. That is, you get to the idea of corporations having rights by virtue of individuals having the right to associate, and therefore corporations should exist, and therefore corporations should have rights. But one could see that as you just saying individuals have the right to associate in corporations, and therefore individuals have the right to associate in these ways. So I'm wondering if you actually get us to the point of corporate rights, or if you've just further specified individual rights in certain ways.
Take two questions, or do you want to answer that straight away?
Oh, sorry.
No,
Yes.
that's how you.
Well, very briefly on this one. At least I'll try to be very brief, but I never am. That's because I'm Irish. You know, we're notorious as a race for too many words. I've now interrupted myself and distracted myself. The focus of the question again, just give me.
Individual rights to associate. Have you
Yes, okay. So I think of rights as being essentially legal entities. So if you've got laws or rules, it makes perfect sense. Think of Hofeld to talk about individuals having rights under those rules. The rights they have under those rules are the rights actively given to them, or the rights they have by, design rights, as it were, or the rights that they have by default, where the rules don't stop them or prevent them doing those things. Now, when it comes to, do individuals have the rights to associate, I hear that question as saying, should we have a system of laws under which individuals are allowed to associate by the laws? Should they have legal rights to associate? Of course, how you answer that question, some people following Kant or whatever will say, well, there are natural rights, and those are the basic rights that should determine what legal rights people should have. I'm not of that moral suasion. I'm more of a consequentialist. I think that what rights people should have under the law is a function of the benefits and costs of having laws of that kind. So when I say that individuals should have the right to associate, I took that as a premise that most of us would accept. And then I wanted to say that, well, look, if you give individuals a right to associate, and in particular to associate in a way that creates a group agent, then you've got to give a group agent rights to whatever is, rights that it requires in order to exist, rights that it requires in order for those individuals to associate in that way. That was the argument. But then the sting in the tail of that argument was you should only give rights to these corporate bodies of the kind you think it's fair from the point of view of individuals as a whole, because we put constraints on how particular individuals can associate on the basis of what the costs and benefits are to third parties, right? Similarly, therefore, we should put limits on the rights that corporate bodies should have that are based on the costs and benefits to third parties, to human beings in particular. The contrast is, one view would say every agent, in virtue of being an agent or a person, in my functional sense, should have rights. That's the view I reject. If you take that view, you'd say that corporate persons should have rights on the same original basis that individual human beings, persons, should have rights. I say no, they should have rights only insofar as that is to the benefit of individual persons. So I'm giving a priority to individual persons. That's the crucial difference.
Yep. I have two philosophical questions for you. The first is about your definition of person. I'm wondering whether in your definition there is room for a strategic person, that is somebody who changes strategically his intentions or plans or commitment. Because according to your definition, apparently you say that a person is an agent that speaks for himself in a way that is very different than speaking about the third person. So I may have doubt about you if you are working according to your commitment. I should not be allowed to have the same kind of doubt about my own commitments or intentions. But typically we may have, I don't know, but a strategic agent is somebody who can undertake a commitment to cooperate with you tomorrow, but before doing that, changes commitment.
Yes.
So, according to your definition, is it possible to call this agent a person? This is a question. The second question is about corporations, and the idea that, again, you, in order to have a personality for the corporation, you may have somebody who speaks in the name of it, talking about his own plans, intention, commitment, yes, blah, blah, blah. And if we have different people who talk about for the corporation, they must be consistent.
Yes.
Yeah. But let me just introduce a bit of experience, not myself, but heard by friends. There are people that has been in the board of directors of large corporation that are strongly against the majority opinion and would like to say publicly, yes, this, and they think that it's not correct, that according to the Italian, for example, corporate law, they cannot do that because they are there in order to represent just the shareholder and not, for example, other constituencies that that are important. So my question is, when there is somebody that speak for the corporation, this entails that the members of the corporation or the corporate body should comply with this will or not. Let me go back to Thomas Hobbes. The distinction between the author and actor in Thomas Hobbes' theory is about explaining authority. So at the end, the idea should be that there is an authority in the actor because the author transfer rights to him by an agreement. So the conclusion is that if this is right, we must comply with the speak in the name of the corporation only if it is based on an authority which is itself based on an agreement among the people inside.
Okay.
But this is making possible the standard corporation.
Let me try to reply briefly to the
Yeah.
question. So on the strategic question, I actually said there were two conditions that a functional person has to satisfy. One, that the person, the agent involved, speaks for itself. That may be a group or it may be an individual. But the second condition was that it generally lives up to the words that it utters. Now, a strategic agent, very interestingly, is someone who makes promises and so on, but doesn't systematically fails because there's always as it were, the other consideration of personal interest that will trump whatever the promise is or whatever the statement in its own name is. Now, whether you should, we traditionally call such agents psychopaths, and as you know, McCann's sort of view of the corporation is that corporations are constitutionally predestined to be psychopathic in that way. I actually I think that's overstated, but I do think there are real problems in the corporate form in pushing a corporation in that direction. However, do you say a strategic agent of that kind is or is not a person? Well, Harry Frankfurt actually introduced a term. He talked about agents who otherwise look like persons as wantons, W-A-N-T-O-N, as in wanton, in this case just going with impulse. Maybe they should be called wantons or deficient persons or something of that kind. But that's my line on that. Now, on the issue about a corporation with the division of powers, for example, within a corporation, a corporation might have rules that the board is the decision-making body, but if for example, the auditors say that a certain way of proceeding is just simply doesn't satisfy relevant auditing criteria, even if these perhaps aren't, legislated for in law, but they're accepted as criteria, then the auditor in that case can have a veto, in effect, over what the board can do. That's already an example of separation of power, so that you've got not just one voice, but two voices. Now, Hobbes, of course, thought that you had to have just a single center of power, an individual, or he thought a majoritarian body. Actually, the discursive dilemma that I give at the bottom of this page and the theorem that Christian and I proved in 2002 was that not only will majority voting not guarantee coherence, as Hobbes thought it would, neither will any system of voting guarantee coherence if it satisfies various plausible conditions. But Hobbes was against the idea of a separation of powers, mainly because he thought if you lifted it over to the point of the state, that it would represent chaos and anarchy. Of course, it was also the tradition defended by his great enemies, the Republicans, as I think of them, that long Republican tradition, believing in the mixed constitution, was precisely believing in each sector of the population should be represented and there should be strict sort of division of powers. He was against that for purely political reasons. I think he brings that over into his argument about all corporate bodies that have to have a single center of power, be it a majority body or an individual. He was just simply wrong about that. And I think the same is true in the issue of corporate governance. There's no reason why you shouldn't have this sort of separation of powers or this checks and balances. Actually, Shan was talking about that yesterday in discussion.
That asset petitioning was always conditional upon limited life. And you've just said that groups should have the same rights as individuals who have limited life. There's a rule against perpetuities.
Yes.
And you change, and the reason they had limited life was so they could define a profit of a voyage for the East India Company or to negotiate people to exit. So it wasn't perpetual asset petitioning. It was always limited life. And so I see an inconsistency I think it's an important inconsistency.
Yeah.
And the last thing is about the notice of question I gave you is that obligation to do no harm, that corporations, the license to operate should be conditional upon not imposing costs on society for their own regulation.
Well, on that second matter, I mean, when I talked about there are constraints on how individuals can associate with one another, like we don't allow them to associate in order to establish a criminal gang, a mafia gang or whatever, you could think of those constraints on individuals associating as constraints that there be no net harm to third parties. And I want to say it's that same constraint that applies to corporate rights, since after all, corporations have rights only insofar as individuals have rights of association. If individuals' rights of association should be governed by a constraint like do no harm to third parties, equally the rights given to a corporate body should be subject to the same constraint. That was the argument there, and you could phrase it in your terms. On the other issue about limited life, I don't think you can say that individuals don't have a right to perpetual life. I think if we did come along with some sort of means whereby we actually could have a perpetual life, and let's suppose all of us could have it, I don't think anyone would say, well, we don't have a right to that. Maybe with a view of future generations and overpopulating the earth, maybe there should be some limit, but it's an open question. Now, it's very interesting that from the very beginning in medieval times, people really enthused about the idea of the corporate person, the persona ficta, particularly on the lawyer's side, because they suddenly saw that you could enjoy sort of immortality. Actually, the theologians took it over in part. The famous book of Kantorowicz on the king's two bodies emphasizes this in arguing that, the church was like a mystical body, and it was a corporate body, and we all lived on forever insofar as it lived on forever. But they thought that even, more mundane bodies like the guild or the town that you belong to, these were persons that lasted forever, and they really thought about them not as having a right to perpetual life, but as thinking that they can have perpetual life, and there's no reason to deny it to them. Now, equally, Blackstone, I think the first of his 5 rights of corporations, the first one, I think, is the right to continue indefinitely in existence. However, like you, I think it's a matter of, I said that corporate bodies should have rights that are determined by the net costs and benefits to the population of individual persons as a whole. That's the picture. Now, if you could persuade me that actually the costs and benefits to individual persons require that corporations should only have a limited life. We heard this morning, actually, from John Ferguson, he's here somewhere, about this man Goyder, who argued in particular for a 50 years limitation, right, on corporations. I just think that's an open normative question, so that would be a good idea. I don't have an informed view on it because I don't know the empirics, so to speak, but I'm certainly not hostile to it.
Right. I realize there's another question, but I'm going to have to bring this plenary session to an end. Please join me in thanking Philippe Pettit. So lunch is served in the university canteen, which is just downstairs, and the next parallel sessions will begin at 2:15 sharp. Thank you.
Other entities, you mean other corporate entities? All right, okay. So, on the second question, I think most of these for denying corporation equality in whatever right it is that corporation, I think, is not but that typically corporations, people who are corporations, certainly my may not be what I said, my premises, right, which is that they should be rights that basically consequences for the society of individuals. I can be persuaded, it depends on the inheritance again, that they should be certainly given the right to speak, you know, to put points of view. But should not be given the right to unlimited political expenditure. We would agree on that.
We agree on the empirics that this is a bad thing. The question is how we construct the argument.
Good. Well, I have worries about the money misuse as well. I don't know, I think that's a point where you can bring about pressure. Of course, it relates not just to corporate expenditure, but other expenditure. So, for example, I think there's no denial, so to speak, of civil right to speech. For example, having campaign funds that we are individuals, it's not just like corporations, but maybe even do not permit private relations to political parties that insist that parties are financially supported by the public purse, as in some countries. So, so we entirely agree on that. The problem isn't giving, I agree, the problem isn't giving the right of speech to corporations. The problem is the right of spending money.
Speech to money.
Speech to money.
Yes. But the first part of my argument, I think, is the most germane to you, because if one is to treat corporations differently on any of these grounds, it's that there isn't this unanimity of voice. It seemed, or to put it somewhat differently, I was a bit troubled by the way you constructed person, in the sense that it seems